It's getting a little dark in my room, so I put lamp next to my desk so you can all see a good view of my pretty face and everything. I'm sure that's real exciting for you. But let's get more serious here and talk about a couple other topics. Obiter dictum, which is what we call dicta in the law, is basically a legal concept that if there's something in a court opinion that isn't really relevant to the deciding of the case or the issues before it, it's not really something that you should cite before another court to convince that judge to follow that particular statement in the prior decision. Okay, let me give you an extreme example. Let's say I'm deciding a case on, I don't know, free speech. And in the middle of the opinion, I say something like the Dallas Cowboys are the greatest football team in the history of pro football. Okay, now that doesn't have anything to do with the case. Okay, so is that good law? Is that something we'd want to bring before another judge? No, because the 49ers, as we all know, are the greatest football team in the history of football. My personal opinion. But in any event, you can see the point, which is this. If it wasn't relevant to the case, it's dicta. And how does it come up? Well, it usually comes up in passing, where the judge might be referring to a prior decision of the Supreme Court or the appellate courts, and they say, well, this case stood for this proposition, or whatever it might be. But it wasn't really relevant to the facts and the issues at hand. So it's dicta. Okay, so be careful when you're putting arguments before a court that basically the other side can say, well, that's really dicta, and that really wasn't necessary to the decision. It really isn't on point to what the case was all about. Okay, that's all I need to say about that. The next topic in the book is judicial restraint and judicial activism. It's generally understood in our society that judges are supposed to be impartial. They're the umpires. Okay, they shouldn't be rooting for one team or another. They should be calling them as they see them. The judges are not, particularly in the federal courts, subject to election or recall except for extreme circumstances. They're appointed for life. And so they should understand their role and be careful of overstepping their bounds, particularly into the legislative ring of making law. Okay. Now, my take, and this is my personal take on judicial restraint and activism, is this. People scream that judges are being liberal and making law when they don't like the decision in the case. Okay. The counter side to that argument is that, one, when judges interpret statutes, they're making law. They're saying what a statute means. That's making law. The other aspect of it is, in our history of jurisprudence, we have the common law, and the judges have been making law for well over 500 years. Okay, so when you hear this thing, judges shouldn't be making law, well, in my personal opinion, that's wrong. Okay, they should be careful about overstepping their role in our tripartite system of government, and they should practice restraint, but they certainly have the authority to make law, and they've been doing so. Okay, so a lot of people, like I said, lately it's been cries of conservatives that these liberal judges are running around making laws. Okay, well, they've been running around making laws forever. So that's my little take on it. Now let's talk about legal analysis of statutory law. Statutory law meaning laws passed by the Congress or the state legislature, or even the Kern County Board of Supervisors or the Bakersfield City Council. Okay. When a law is passed, many times a judge has to interpret what that law means before he can apply it to the facts at hand in a particular case. Okay, this may come as a shock to you, but most of the laws passed are, kind of ambiguous and aren't easy to read, and even judges have difficulty finding out or trying to figure out exactly what the law means. Okay, to do that, they generally use what we call rules of construction. The rules of construction, the idea is to determine what the intent of the legislature was when they passed the law. Now, the first rule of construction that we use actually really doesn't use legislative intent, okay? And it's the first one we use, so there's kind of a paradox there. Okay, the first rule of construction is what we call the plain meaning rule. And what the plain meaning rule means is that if the language of a particular statute is unambiguous and its meaning clear, the court will construe the statute and apply it using the ordinary meaning of words. Okay, now, a lot of times the legislature will define specific terms, but if they don't, the court will use the ordinary meaning. Okay, dog means dog. It doesn't mean cat. Okay, so language by its nature is subject to ambiguity, distortion, and lack of clarity. The plain meaning rule obliviates this need to delve into a lengthy inquiry as to the intent of the legislature. So why do judges use it? It's a heck of a lot easier. And if later on the legislature doesn't think that the judge got it right, well, they're free to change the law and write it in a more clear manner. Or remember, the legislature can change the law anytime that they want. The other reason that the plain meaning rule works is that determining exactly what the intent of the legislature is almost, it's extremely difficult, if not impossible, okay? Politics, as Bismarck said, is like making sausage, okay? The end product looks pretty good, but if you went back into the factory and saw how it was made, it's kind of pretty ugly and gross, okay? That's what Bismarck was talking about. And so figuring out why particular lawmakers voted for a particular bill or why a particular law was passed is sometimes difficult, and at other times impossible. And furthermore, a lot of times congressmen don't even read the law that they're passing. Okay, like the Patriot Act that limited our freedoms, okay, and we're litigating over right now. Most of the congressmen admitted that, it's a 1,000-page law and they didn't even read it, okay? So, also, laws are a lot of times enacted out of compromise, which means people vote for things that they really don't like, but they get something in return. Okay, that's politics, and unfortunately, our Congress right now doesn't understand that concept of compromise, giving something to the other side so you can get something back. That's why we're in a state of paralysis. At least I think so. One of the other doctrines the court uses in terms of interpreting statutes is the doctrine of strict construction. Tradition has determined that certain types of laws should be strictly construed, okay, which means that we're not going to extend them beyond the terms of what the law says. And the most common types of laws that are strictly construed are criminal statutes, okay? The public, if we're going to punish them when they violate a law, need to know what the law means. Also, you can't punish conduct in the future. Okay, that's called an ex post facto law. So you can't punish something for something that was legal when you did it, and later on they make it illegal. Okay, let me just give you a quick example. Let's say the City Council of Bakersfield passed a law making it a crime, a $100 fine for uttering any obscene word. Okay, let's put aside the free speech arguments there for a second and just kind of ignore those and look at the law itself. Okay, the court would probably strike that down on two grounds. One is that the law is ambiguous. Okay, what is exactly obscene? Okay. The other, so the public doesn't know exactly what words it could say and what words it couldn't say. But let's say the court went ahead, or the Bakersfield City Council passed a law making it illegal to utter the word motherfucker. Okay, and I went out and I went to the first cop I saw, being the rebel that I am, right, and said, "Oh, you mother ducker." Okay. And then they brought me up on criminal charges, tried to fine me $100. Well, The court would say, he didn't say MF, he said mother ducker. Okay, if you wanted to make that illegal, you should have said that. Okay, so that's just an extreme example, and I like to use extreme examples because they kind of stick in your mind. Okay, it's not like I like to drop F-bombs all the time, but you'll probably remember this. They're going to strictly construe statutes. Okay, like one other type of law that the judges will strictly construe is one that is what we call an abrogation of the common law. Remember, the common law was created by the judges, so maybe they just feel they should jealously guard it. I don't know. But if the legislature, which is their prerogative, decides that the common law isn't good public policy, or whatever particular interest group doesn't like it, and they decide to change it and make a new law or outlaw a particular decision by the court, they're free to do so as long as they're not violating the Constitution. And what the court will do kind of in response is this. They will say, okay, you've taken away the common law, which we created, and that's fine, but the statute you replaced it with, we're going to strictly construe it, and to the extent possible, we're going to keep the common law that we've already made in place. Okay, so that's just one other example of the doctrine of strict construction. I'm going to quickly cover legislative history. Basically, we delve into legislative history when we can't use the plain meaning rule to determine a statute's intent. We can't determine what the statute means in the context of other laws that were passed as a part of the particular law, things like that. If it's still ambiguous, one argument we could make to a court is to determine the intent of the legislature. We can look at the history of the bill as it got made and worked its way through Congress or the state legislature. Okay, it's very unlikely you'll have to research legislative history, and frankly, it's a pain in the ass. So hopefully you'll never have to do it. We really will only do it as lawyers as a last result. And judges are very, suspect about arguments on legislative history. Okay, so this is better left to the appellate courts and the Supreme Courts of the state, and Supreme Court in Washington. But it is there, so we will briefly cover it. Okay, so what is legislative history? Okay, this includes the documents and records concerning the process by which the law became a law. So what do we look at? We look at documents that may be presented during hearings before particular committees when the law was going through the legislative process. Okay, we can look at the text of the bill and see how it was amended later on, and maybe compare the original text of the bill to the final version to figure out, what changes occurred during the course of the bill's time in the legislature and the final product, and say, well, they must have meant this because they made all these particular changes to the law in that regard. Okay, we can look at records of committee hearings, reports of committees. We can look at the debate on the floor of the Senate, for example, to determine what the legislature might have intended in that regard. And presidential statements are things like, the president might have somebody introduce a bill, and he might make a statement, we need a law that covers this, and so I'm going to have my congressman here introduce this law because we need to, stop, the distribution of child pornography on the internet, or our children from getting, synthetic drugs, whatever it might be. Okay, so that's something that you might look at. Okay, but here's the caveat on legislative and churches. Like I said, okay, one last comment on statutory interpretation, and it's an important one, which is this. If a law is at all ambiguous, judges like to be fair. Okay, most of the judges I've dealt with are good people, they're smart people, and this is the reality. They're human beings, and they are going to look, if a law in their mind is extremely unfair and the language is ambiguous to the law, they will look for any way they can to not follow it. Okay, so as your book says here, very few judges will blindly follow a technical rule if it will result in a manifestly unfair decision. They can justly reason that the legislature never intended such an unjust result. So, like I said, judges, if they think it's unfair, they're not likely to follow it. Only if the language is unambiguous. Only then. Okay, the last part of the chapter talks about reasoning by analogy and deductive reasoning. And they provide you kind of with a case example. I'm not going to go over that point by point, but this is what we do in legal research. And it all kind of boils down to these points. Okay, what we do is we find, we read, and we synthesize, which means put together all of the relevant authority to extract a rule of law, and we determine whether it's binding, mandatory authority, or it's just persuasive authority. Then we take those rules of law from those cases and we apply them to the facts of our case. And then we reach a conclusion. Okay, this is what we'll get into this later, called the IRAC, issue, rule, application, conclusion. Okay, and we'll get more into that later in the semester. Okay, now in terms of reasoning by analogy, in our common law system, reading cases is central to our legal analysis. Rarely are we going to be able to just look at a statute and figure out whether we're going to win or lose a case. Okay, we have to read the cases that interpret that statute to extract the rules of law that we believe are relevant. Okay, in deciding whether a past case should apply to the case presently before a court and the impact the earlier case has involves reasoning by analogy. What things are similar, what things are different. Okay, it kind of goes back to Sesame Street. One of these things is not like the other. Okay. Reasoning by analogy involves finding a past case with facts that appear similar to the one that the court must decide. Then compare the facts of the two cases and compare those similarities and differences. Then we have to decide whether the facts are so substantially similar that the past case should be controlling or determinative of the result in the present case. If they're substantially different, then the past case may not control the present case. And we have to either look for other law or the judge is kind of on his own. Okay, and that's what we do as lawyers. If the case helps us, we say the judge should follow it. If the case hurts us, we try to distinguish that and tell him that he should not follow it. And he should follow the cases that we bring before him.